Good morning, everybody. Hello.
Good morning, sir. Good afternoon, sir.
Oh, sorry.
Yes.
Good afternoon.
Good morning, sir.
Good afternoon. Good afternoon. I've been corrected. Good afternoon. This is landlord class, Abi.
Yes, sir.
How many of us are ready for the class, as I'm saying? No. Have we formed quorum? Has quorum been formed? Can you hear me?
Very
Yes,
well,
sir.
sir.
Okay, so I can start my lecture. Show it, Kuro. Please hold on for me. I will join you in a few seconds for the lecture. Yeah, good afternoon, everybody. Hello, good afternoon, class.
Good afternoon, sir.
Good afternoon. Good afternoon, sir.
Good afternoon.
Today, I'm going to start my lecture on customary and family land tenure system. And before we go into that, it's very important for us to be able to understand what is land tenure system, what does it mean, how many types of land tenure system do we have under the customary land law, and how is the land being managed and administered under the system of land holding, and then the implication of non-compliance with the land tenure system. The impact of the Land Use Act on the customary and family land system will also be discussed. And at the end of the lecture, the main purpose of this lecture is to introduce all of you to the core element of customary land tenure system under the Nigerian law. And by the end of the discussion, my desire that Students will be able to understand the diversity of the customary land tenure in Nigeria, and you should be able to understand and explain the nature and characteristics of customary land tenure, the management and alienation of communal land, the nature and characteristics of family land tenure, the concept and the scope of family property, the rights and privileges of family members, the rules and management of an alienation of family property as well as communal property, and all the remedies, if any, available to a community member or family member when land is improperly alienated, and how can family property be alienated or terminated to create individual land tenure system. Is that clear? Do you understand that introductory part?
Yes, sir.
Yes, sir.
Oh, sir.
As to the manner of land tenure system under the customary tenure in Nigeria. Very well. It is established principle that customary law is not uniform all over Nigeria. It varies from one locality to the other with some local variants. So what you find in one, there may be some element of familiarity or uniformity, but there is slight modification as you continue to move from one jurisdiction or from one community to the other. And so what you find in maybe Yoruba community may be slightly different from Benin community, or to the Igbo community, to the Hausa community, to the people of Niger Delta, as well as the northern part of Nigeria in terms of the way they hold land. But the simple concept of land tenure, it's the mode of holding land, the ways and manners by which our people hold land, and the way they administer it for the benefit of the members of the community or members of the family, whichever. There are divergent views as to how manners of land holding under the customary land tenure. There are three schools of thought on that. The first one is by Dr. Coker, which he expressed in his book, Customary Land Tenure. And he was of the view that the basis of holding land in Nigeria is communal. And relying on the case of Ahmadu Tijani against Secretary of Southern Nigeria, reported in 1921, appeal cases at page 399. The other forms of ownership recognized, another school of thought is from Dr. Elias in his book, Nigerian Land Law, when he wrote that the unit of land holding is family. To them, community do not own land, it's only the family that can own land. And for that purpose, they are of the view that only family land tenure should be a subject of discussion. The third view was by Omotola, who was of the opinion that land tenure system is not communal, it's not family, it is individual. That is, one person must be the first person to settle on the land. There must be the principle of first settler. And so the person who first settles, it cannot be every community that move a mass and claim a whole land. It is only, there must be one person who first came there before that person has a lot of children, has his family, and from his family, it grows to the bigger community. So all of them tend to share their views depending on the way they understand the law. But like I said before, land holding system varies from one community to the other. In my very recent practical work that I did in a community in Niger Delta, in Aniocha, we found, as a matter of fact, that people migrated like a group from one community to the other. So when some group of people migrate from one place to the other as a group, and they hold on land in that place, you cannot say the first settler is one person. So it is wrong. I won't support Professor Motola's views that it is all cases that only individuals starts ownership of land. We may find in some communities, some group of people may migrate from one location to the other to settle in one particular community, and they hold their lands as a community, and administer it as a community. If we take places like Ogwashuku, Buluku, Buno, all those places in Delta State, people will tell their history that they migrated in group from one part of the country to the place, and then land is being held as a communal ownership, and it's being documented. So whichever way you look at it, there is no way you look at it that is not correct. Because today, we still have community that they have communal land ownership. We still have institution of family land tenure. We also have a situation whereby even community and family that have sold their land, and we have individual land holding system. So we are now moving away gradually from totally communal land holding to family, and from family back to individual land holding. So whichever way you look at it, it's still important for us to assume that today there are three views, three forms of ownership, which is recognized under customary law: communal land holding, family land holding, and individual. The locus classicus on communal land holding is the case of Amadu Tijani against the Secretary of Southern Nigeria. I want every member of the class to go to the library to go and read that case from beginning to the end. It's reported in 1921, appeal cases at page 399. Lord Haldane made the locus classicus statement to the effect that land belongs to the community and never to an individual, and that everything you needed to know about communal land system is already stated in that judgment of Lord Haldane in the case of Amadu Tijani against the Secretary of Southern Nigeria. So they're happy. I was trying to get, also done for me. I was just trying to. Now, before I go further, class captain, are you on the chat? Are you on the Zoom? The class governor. Hello, is the class governor on?
Yes, sir. I'm the assistant class representative.
I don't know. I have something like handout, because if you have to be writing me while I'm teaching you, you might find it a little bit difficult, and it might take a long time for us to.
I'll reach out to you, sir, so I can get them.
Okay, so please reach out to me after this lecture to see how we can get my notes on the customary land tenure that can assist you. You can read it so that it will become clearer in my mind.
Thank you very much, sir.
You're welcome. Now, customary land tenure. Under the communal land holding system, land belongs to the community. It's never to the family, never to the individual. In other words, the land is being held by the community as a unit, And it is the head of that community, which may be an Oba, an Obi, or some group of people. In some places like Aniocha, they will tell you it is the federating units, the DIMES, that has the power to administer the land and not their OB. In some community, in Igbo land, communal ownership of land is not is vested in the management of those land is not vested in Eze. It could just be some federative, depending on the way the place is configured. But the generality of the opinion is that when land is owned as a communal thing, there is no individual that can come and lay claim, or a family that can lay absolute claim, unless that land has been given to them. And the person to administer those land for them, for the benefit of the community, is either the Oba, if it is in the southwest where they use Oba system, or the Obi in a place where the Obi system, where the Obi has the power to allocate land, or group of people like in the south, in the Delta, Aniocha, the DIMES, the head of various sections, federating units of the community. And in some Igbo land, it is only some group of community too, and not just one single person like Obi who will say, go and take land there. No. When it comes to land, the system, if you read Obi on land system, land tenure system in Igbo land, they also adhere to this principle. But if the major point there is that individual family cannot claim absolute ownership of those land. The radical title to those land is vested in the community for the use of the present and the future generation of people within that community. And so if you read the case of Ahmadu Tijani against the Secretary of Southern Nigeria, it's very clear. He said land management for purposes of administration, management, alienation, it is vested in the overall central authority, who does that for and on behalf of the community. And the right of any community member is his right to be allotted land. He has the right of allotment. And an allotment of land to a member of the community does not mean a total sale. It is only have the right to use, to enjoy, to farm. In some community, the farming right is not absolute. Where they practice shifting cultivation, they can move from one place to the other for purposes of farming. It does not necessarily mean that those persons have absolute right. But where a land has been allocated or allotted to an individual or a family for use of farming, they can continue to use the land so long as they acknowledge the title of the community on the land, and the land is not later required for public purpose or for the use of the community. They can continue to use the land forever. The father will use, it will transfer to the son, but it can never challenge the customary, the communal ownership of such land. 2, after the Land Use Act, Section 36 preserves the existence of communal ownership of land. It says that if the land has been in existence before the Land Use Act and it is used for agricultural purposes, that land will continue to remain so. Section 36, subsection 2. And communal land is not expected to be alienated. It's even a criminal offense to alienate communal land or land that was held before the land is as a community owned. Otherwise, it becomes a criminal offense. So that's to show you that even the Land Use Act recognizes the existence of communal ownership of land and is still respected up to date. Did you get that?
Yes, sir.
No, sir, can you recap a bit, sir?
Which area do you want me to do a recap?
Where you mentioned an offense to alienate communal land, sir.
What I'm saying is that even the Land Use Act in section 36, subsection 6, prohibits the sale of land that is used for agricultural purposes before the enactment of the Land Use Act. In other words, under section 36 of section 2 of the Land Use Act, land that are being held before the Land Use Act is passed for agricultural purposes, which is usually you find in the communities or in the rural area or non-urban area, those land presupposes and it shows that customary land, that the Land Use Act recognized customary method of holding land that was in existence before the Land Use Act. That's the point that I'm trying to make to you. Is it
Thank you,
clear
sir.
to you?
Yes, sir.
I've seen what I'm looking. Now, another thing that you also need to know about communal land is that the community, the land in a community is corporately held. It is held as an entity for the benefit of all the community. And that's why Lord Harding said that in every case, the chief or the headman of the village or community has charge of the land, and in loose mode of speech is sometimes referred to as the owner. He is to some extent in the position of a trustee and holds such land for the benefit of the community. In other words, the corporate power of management is divorced from ownership. Ownership of the land belongs to the community, but the management can be done by some few people, either by the head of the community or by the chief or headman of the village or some group of people that the community may have appointed to administer the land for the benefit of all members. But land in the community is corporately owned. It is not individually owned. And when Lord Harding was talking about trusteeship of family head, he was not referring to trusteeship as you find it under the English doctrine, where you make your family head or the community head or the Oba accountable for what he has done. No, it's used in the loose sense that this is holding it in trust, but they are not necessarily accountable, although there are cases that tends to show that the family head could be accountable, but not in all cases. Now, what are the rights of every member of the community? Every member of the community has a right in communal land, which varies from locality to locality. A member has equal right to a portion of communal land upon which to build and to farm. Are you getting me now? Every member of the community has a right to allotment of land for purposes of building the house or for purposes of farming. The authority for that is the case of Amadou Tijani against the Secretary of Southern Nigeria. I can mention this several times because that's the locus classical. Now, what is the nature of grant given to a member of the community? A member allottee of a communal land does not become the owner of the land. He only enjoys exclusive possession, while the title in the land remains with the community. Consequently, while his allocation subsists, the chief or the headman or B or any other person cannot make an inconsistent allocation of grant to another person without consultation and agreement of the original allottee. So if a land has been granted to somebody and is on that land the headman or the community cannot make another grant of the same land to another person. That will be inconsistent with the grant that he has already made. If he wants to do that, he will need the consent of the previous allottee or is before he can make such thing. He will need his agreement. Otherwise, such things will be wrong. I want you to see the case of Adewuyi against Adeyeye. 1963, one all Nigerian law report at page 52. You can also see the case of Oko and Olotu, 1953, 20 Nigerian law reports at page 123, 123. Those are the authority to support the proposition that a communal head cannot make any consistent grants. Once a grant of land has been given to another person, he enjoys exclusive possession and can only be displaced unless you seek his consent. In some cases, in some jurisdictions or some localities, the grant of land by the traditional authority exhausts in the allotee members permanent rights in terms of ownership. Remember, I told you before that customary law varies from one location to the other, and it is not fixed. What you find in one community may differ, but slightly differ from the other. In some community, the grant or allocation of a land to a member may amount to absolute grant. That's an exception to the general rule. I want you to see the case of Adewuyi against Adeyeye.
Hello, sir.
Yes.
Hello, sir. I'm very sorry to bother. Just can you repeat the exception, sir?
Which section? I didn't.
The one that you just mentioned.
I was quoting cases for you. I didn't quote section.
No, the point, the principle you mentioned before you mentioned the case, Adewuyi.
The principle I said was that an allocation of land or allotment of land to a member of the community grants is entitled to exclusive possession of the land, but that does not confer ownership on him. Ownership of that land is still vested in the community. The second, and therefore, he can enjoy exclusive.
So I think he's referring to what you said about absolute possession. You're mentioning the exception.
Eh?
So I think what he was referring to is when we were talking about absolute possession.
Let me call you back. Hello?
Hello, sir. I said I think what he was referring to is when we were talking about the exception.
Now, the exception to the general rule is that in some communities, the grant of land to an individual may amount to absolute ownership. That's the exception to the general rule. So, for instance, if it is under Ijesha custom or Ile-Ife custom, the grant of the communal land could, in certain circumstances, amount to an absolute grant. And that's why I said you should go and read the case of Adewuyi against Adeyeye and the case of Aragbaju and Onitiju. Aragbade and Onitiju Aragbade and Onitiju is reported in 1962. One All Nigerian Law report at page 32. I have given you the citation for Adewuyi and Adeyeye, which is also, if you want it again, is reported in 1963. One All Nigerian Law report at page 52. So if you read those two cases, I've given you about 3 cases. The first principle established that as a general rule, the grant of land to a communal member or a community member does not confer absolute ownership on him. But it's also possible please hold on for me, student. Let me just dispatch these people that. Bumi, I waited for you in the house. I'm in the faculty office and I didn't come with your letter. So come. And then you come to the faculty. Yes, come to the faculty. Hello, students. Can you hear me? Hello?
Yes,
Hello?
sir. Can hear you. Yes, sir. Can hear you.
Yes, sir.
Where did I stop? To what extent did you hear me? I don't like this room. Where did I stop?
Aragbade and Onitiju, sir.
Aragbade and Onitiju, which is an exception to the general rule that a grant of land means you are just being you just have an exclusive ownership and not exclusive possession and not absolute ownership. Now, under the Benin culture, for example, all land in Benin is owned by the community for whom the Oba of Benin hold the same in trust. It is the Oba of Benin who can transfer land to any individual, the ownership of such land. Only the Oba of Benin can transfer absolute ownership of land to somebody in Benin culture. I want you to see the case of Arase and Arase. 1981, 5 Supreme Court, page 33 at page 58. An observation of Idigbe JSC. Also see the case of Otogbolu and Okelua, where the Supreme Court by Obaseki JSC said in relation to communal land that each members of the community, generally within his economic capacity, do acquire as he desires interest in piece or parcels of communal land, which he can also transmit to his offspring, and which is entitled to protect and prosecute by action. In other words, he has a claim to his right against any other members of the community who trespass on the land, and to that extent, the interest of community is displaced or postponed. What the case in Otogbolu and Okelua is trying to suggest is that in some circumstances, the grant of community land to an individual may amount to transfer of absolute possession, depending on the community. So, while a community member has the right to be allotted land to farm and to build, it is not the same thing for strangers. Strangers are not entitled as of right to any portion of communal land, either to live or to farm on. Generally, the general principle is that the stranger to a community is not entitled to the grant of land, either to live or to farm. But as we talk later, in certain and deserving circumstances, community may grant land to a stranger to farm under the doctrine of customary tenancy, which will require him to pay tribute to the communal overlords. I'm not going to talk about that. When our colleagues will come and take you on that, they will teach you what customary tenancy is all about. It's not mine. In cases like Lasisi and Chubi, the practice of customary tenancy is well recognized and well documented. Now, because of civilization and because of expansion, customary ownership of land is dwindling. We now move to family and individual land holdings. It's dying gradually. It's decreasing. And many factors is responsible for that. The existence of compulsory acquisition of land by government, the introduction of the Land Use Acts, the law establishing state land that gives the state the power to take over land and then call it state land, has also decreased the influence of totally communal land only. If you live in Lagos, you'll find out that even some of those communities that are far off, the mode of holding land is reducing. A lot of people have their land in those communities as private owners without necessarily being a member of the community, either by purchase or by absolute grant. Do you hear me?
Yes,
Hello?
sir.
Can you recap what I've said before I move to the next topic? Do you understand what I said about communal ownership? And what are the salient case laws that you needed to take a look at to understand this principle? Class captain or anybody that wants to make contribution, you can raise your hand. I can recognize it. Hello, are you there?
Hello, sir.
Hello, sir. My hand is up.
Some hands are up.
Yes, sir.
Oh, yeah, ask your talk now.
Okay. Good afternoon, sir.
You have to.
So far you've spoken that about that the customary law varies from community to community, and the rules are determined by the custom of each community. The cases that you have given are Oko and Olotu, Adeyeye and Adewuyi, Aragbade and Onitsiju. You gave a general rule on the allotment of land. You said that land can be allotted to a member of the community, and that allotment will vest exclusive possession on that member, even though ownership of the land still remains with the community. So he has exclusive possession, but the ownership of the land is still with members of the community. So if, for instance, they want to use the land maybe for something for the good of the community, they might be able to still use that land for that purpose. Then you spoke about that being the general rule, the exception being Aragbade and Onitsiju. In some communities that grants allotting land to a member of the community can amount to absolute possession. Then you mentioned the Benin custom, where all land belongs to the community, which the Oba holds in trust for the community, and how only the Oba can transfer absolute ownership of that land. You mentioned the cases of Arashe and Arase, and Otobolu and Okeoluwa, where Obaseki GSC commented on the Benin custom of land ownership. Then you've also mentioned the fact that customary tenancy is dwindling am I still audible?
You're audible. I'm hearing you. You are doing a
Okay.
very good summary.
Okay, sir.
That was why I didn't
That-
cut it short.
Okay, sir. Then you mentioned that customary tenancy is dwindling because of the things like the enactment of the Land Use Act, which, for instance, vests all the land in the governor of the state, and things like modernization. So people will prefer to own land individually now rather than continue with communal or family land ownership. I'm curious, sir.
Thank you. But from what you have said, there's one important case that you omitted, and it's very key.
Okay, let me list the
case.
cases I have. I have Okuanolotu, Adeyeye and Adewiyi, Aragbade and Olutiju, Arase and Arase, Otobolu and Okeoluwa.
You missed the case of Amadou Tijani against the Secretary of Southern Nigeria. That is the locus classicus case on customary and family land tenure system. In fact, anything about in Nigeria about customary land tenure system, the beginning, the genesis, the locus classicus case is Amadou Tijani against Secretary of Southern Nigeria. And I will employ everybody in the class to go and read that case. It's very, very good. It's very important.
Thank you, sir.
Next person who also want to make a try. Yes. Who else?
Okay, so I just want to add to what you said. I didn't hear mention this. So you had said that strangers are not entitled to any portion of a land in the communal system, either to live or to farm. That is a general rule. However, an exception is the doctrine of customary tenancy, where a stranger will have to pay tribute to a communal lord. Yes, that's the point, sir. Hello, sir. Can you hear me?
I'm back. Who was talking before the network issue?
Yes, I tune in, sir. So I was adding to what you said that in customary or the communal ownership of land, that strangers are not entitled to any portion of the land, either to live or to farm, and that is the general rule. However, the exception is the doctrine of customary tenancy, where a stranger will pay tribute to the communal lord. And you mentioned that this would be discussed in subsequent classes. Yeah.
That will be taken in subsequent classes, and whoever is taking that will take you that. Just hold on for me. I wanted to attend to the thing. Hold on. Can we continue? Can we continue?
Yes, sir.
Okay, good. Now, the second mode of holding land, and which is very important, which we are going to spend a lot of time on, is the family land holding. There are some discussions to the extent that family land holding is no longer relevant, the same line of argument from some people. But I can tell you very well that family land holding is one of the important features of customary land law and the existence that has never been in doubt. Sorry, I was having internet issue. The university internet is not working, so I think I have to use my own hotspot so that we can enjoy the lecture. Like I said, the speed acting CJ in Lewis and Bankole said all properties were family properties, and that in the case of Lord Haldane is still in favor of communal ownership. And that position held by Speed in the case of Lewis and Bankole was affirmed in the case of Bajulaye and Akakpo, when Lord Butler said in Bajulaye and Akakpo reported in 1938, 14 Nigerian law report at page 50, that I am perhaps of nearly a generation since that judgment was delivered in Lewis and Bankole. The institution of family head is still a living force. Even today, the institution of family property is still a living force. So family land holding or family land is still alive and will still exist because family, the institution of family continue to wax. Now, the question you now ask yourself is, what is family property? Family property in our own context refers to those land that are vested in the family as a corporate entity, distinct from its members. And it is an invaluable rule of customary land law that no member of the family can claim in the family land. Land is corporately owned by the family, and the onus of proof or to displace the corporate ownership of land by the family the onus of proof of displacing absolute ownership of land by the family will be on that member who claim individual ownership of such land. And so the principle of law is that land being owned by the family is corporately owned, and no individual can claim absolute ownership of it. I want you to see two cases where the Supreme Court has they have found this position of law. See the case of Atwanya and Oyekere, 1975, 3 SC at page 161, 3 Supreme Court. Atwanya against Oyekere, 1975, 3 SC at page 161. Also see the case of Sanusi and Makinde, 1994, 5 Nigerian Weekly Law Report, part 343, at page 214, where the Court of Appeal held that where a family land has not been partitioned, it still remains a family, and that no member of the family, whether any form of improvement or not, the land is still a family property. Can somebody move it? Somebody didn't move it. Is this thing there and it's disturbing the class? I need to find out who the person is. Now, what is the meaning of a family? Who and who constitute a member of the family? The word family in law, in customary law, has both restricted and extended meaning. Restricted meaning, according to Dr. Elias in his book, means embodied politics, which only includes the man, the wife, and his children. But in the case of Bajulaye and Akakbu, the word family was extended to connote any group from a nuclear unit to extended family, thus encompassing a man, his wife, his children from 1,000 descent, tracing descent from common as children. It also means people that can trace their descent to that family. Family may also be referred to as metaphysical, but that may not necessarily be. Where in the case of the testimony of Elesi of Odogbolu before the West African Commission, he said those that are yet unborn. So he has a very larger distance. But for the purpose of succession to family land, by operation of law, the court has usually given restricted meanings unless there is a local custom is proved, specially pleaded and proved to the contrary. Now let's take the position one by one. Who are regarded as members of the family? Children. The children are automatically regarded as the members of the family. Any children, any child of the disease is regarded. Number Otoloni, do you want to ask a question?
Yes, sir. Good afternoon, sir.
Sir, please, I wanted to ask you to please repeat the case where you said the family include those who could trace their descent to the family. The case where you mentioned it.
That's the case of Bajulaye and Akakpo.
Okay, thank you very much, sir.
I think I've given you the citation before.
Yes, sir. Don't worry, sir. Thank you, sir.
Now, the children, under the Yoruba native law and custom, family includes both the male and the female of the deceased. Yoruba people don't discriminate whether you are a male or female, so long as you are an offspring of the deceased person. You are regarded for purposes of inheritance. You are also entitled to inherit in the estate of the deceased person. If you see the cases in relation to Yoruba race, Kuka and Kuka, 1938, 14 Nigerian Law Report. Durojaye and Mustafa, 1975, 7 Nigerian Law Report at page 58. Lewis and Bankole, I've already stated that before. But under the Igbo custom, which is strictly male-oriented, but not all the Igbo land, but some part of Igbo land, majority of Igbo land, family members generally excludes daughters. You can see the case of Nesinaya against Okagbue, 1963, All Nigerian Law Report at page 352, Mojoku and Mojoku. Compare it with the culture of the Benin people, Ijogbe, where the deceased property divorced only to the eldest son exclusively in accordance with the rule of primogeniture. Under this rule, the eldest son is expected to look after the younger one and may sell the house over the wishes of other children or treat it as his own. If you see the case of Idehe and Idehe, for those of you who have done family law in year 3, you must have come across those cases. Idehe and Idehe, 1991, 6 Nigerian Weekly Law Report at page 191, and also the case of Lawal Osula against Lawal Osula, 1995, 9 Nigerian Weekly Law Report, part 419 at page 259. So you can see that the culture varies from one community to the other. Whereas in Yoruba land, this is the case of Taiwan Sarumi, male and female, are entitled to inherit. That is as far back as 1913 in relation to custom in Lagos. In Igbo land, which is strictly male-oriented, family excludes daughters. Please hold on for me, class. Hello? Sean, what's up? Yes. So let me know the cost of filing. And then put the work in a flash drive. They will tell you what to do at the Supreme Court and get back to them. Okay, bye. Okay. So sorry, I can see Mary. Mary, I can see your answer.
Yes, sir. Yes, sir. Please, sir, can you repeat the cases after Mojekwe and Mojekwe? I couldn't really hear my network.
Hey, nobody you want Mojekwe and Mojekwe, which was Mojeku and Mojeku, that was for the Igbo people. But what I said there was that if you contrast what you have in Yoruba land, this are this, that of Igbo land, to that of Onitsha and Benin customs, where the property of the deceased property will devolve on the eldest son exclusively in accordance with the rule of primogeniture, which means that the eldest son will inherit the property and take care of the younger ones. He may sell the house or the property with or without reference to them. That is the case of Idehe and Idehe. 1991, 6 Nigerian Weekly Law Report at page 198. And the case of Osula and Lawal Osula and Lawal Osula, 1995, 9 Nigerian Weekly Law Report, part 419 at page 259. Do you get me now?
Yes, sir. Thank you very much. Yes, sir.
Okay. Now, what is the position of the widows? Under the native law and custom, a widow does not come into the fold of a family for purposes of succession. In other words, a widow cannot inherit her husband's property. Read the case of Suberu and Sumonu, 1957, 2 FSC at page 33, Duro Jaye and Mustafa, Shogunro against Shogunro, 1929, 9 Nigerian Law Report at page 79. So when we are talking about nuclear family, we're talking about wife, husband, wife, and children. For under the customary law, women or wives cannot inherit their husband, only the children. What about the slaves and the domestic servants? For purposes of succession, they are totally excluded. Unless the testator express the view that those slaves can be given inheritance. If he did not say so, slaves are not entitled to inherit. I want you to see the case of Dabiri against Bajumo, 1961. One on Nigerian Law Report at page 225, particularly at page 231.
Could you repeat the case again?
Where Taylor, slaves with particular reference to the family and their descendants have regarded themselves and were being regarded as members
Sir,
of
please,
the
could
family.
you repeat the case again?
I'm still talking. Allow me to finish. In the past, slaves with particular reference to the family and their descendants have regarded themselves and were being regarded as members of the family of their overlord under native law and customs. The case is the case of Dabiri and Bajumo, 1961, one Nigerian Law Report at page 225. Have you heard me now? Have you heard me now? Are we good to go?
Yes, sir.
Yes, sir.
What about relatives and collaterals? When we talk about relatives and collaterals, we are referring to cousins, aunties, aunts, uncles, the family. However, the founder of the family may, by his own will or own act, include the relative, as done in the case of Shogbeson and Adebi. Generally, aunts, relatives, and collaterals are excluded, but they can be included by the will or by his act, as done in the case of Shogbeson and Adebi, reported in 1914, 16 on Nigerian Law Report at page 26. As to the right of the grandchildren, some of you are grandchildren of many people. As long as your parents are still alive and the direct children are still alive, grandchildren and other descendants are not members of the family for purposes of succession. Succeed his own parent on his parents' death. See the case of Lewis against Bankole that I've cited to you before, or the case of Balogun and Balogun, 1943, Naiwaka at page 78. Grandchildren are, for purposes of succession, are not recognized unless they succeed their parents after their death. So when we said that, when we talk about family, in the context of family, in the context of customary law and family land holding, we refer to family to mean a group of persons bound by law and entitled under the customary law to inherit jointly the property of the deceased founder or the head of the family upon intestacy. However, how many number of people can constitute a family? From what we have said now, you know that if you are not up to 1 or 2, or if you are not up to 2, 3, or 4, you cannot constitute a family. But that's not true. The Supreme Court has said in the case of Abeje and Ogundairu that a single child is sufficient to constitute a family. I'll give you I don't have the citation of Abeje and Ogundairu here, but remind me in the next class. I'll make it able for you. So let me have your understanding of the later part of it before because I will stop here today. Hello, class. Can you hear me?
Yes, sir.
Yeah, I want your comment, your understanding, because this is the right place for me to stop for today.
So I have a question, sir.
Go ahead.
Good afternoon, sir.
Good afternoon.
Where does Omonile fall under this customary land tenure system? Is it under family or community?
Who are the Omoniles? What do you mean by Omoniles?
These families that sell land in Lagos.
Is it only Lagos that they sell land?
Yeah, but here in Lagos, it appears that they are recognized by law.
There's nothing like they are recognized. When they say Omonile, that means they are the children of the owner of the land. That's the simple meaning of Omonile. The children of the owners of the land. So if you don't own the property somewhere, you can't claim to be Omonile now. Can I claim to be Omonile in Oshodi and then claim to be Omonile in Agege or claim to be Omonile in Lagos Island? You must belong to one family or a community. When you talk about Omonile, it is either the agent of the head of the community who put his people there, or a members of the land-only family who is protecting the interests of their family land. Do you understand that now?
Yes, sir.
So if a family does not have a land in a particular locality, no group of individuals can come and be saying because they speak the one language, they are there for money. No, there must be a link between you and the land in question. If you don't have a link, you can't be claiming your money. Which your money? No, even community, you must be a member of that community for you to assert rights over the land that belongs to the community. And you cannot assert that right without the consent and concurrence of the family of the communal head, who is the overall person responsible for the management of the land.
Okay, sir. Thank you.
Good. Any other question?
I have a question, sir.
I'm listening to you.
Sir, can you hear me?
I can't hear you. You said you have a question. I said, go ahead.
Please, when you first started the class, you mentioned three opinions of three different persons. You said communal land holding tenure system, the family, and individual. I just wanted to clarify, please. Are those the three types of customary land tenure system?
The customary land tenure system does not even recognize individual ownership of land. Most prominent among them is community land holding and family. But with the space of time, people buying land or allocation of land to individuals, individual ownership of land is also now recognized as a means of holding land under the customary land system. And if you listen to the lecture in the course of the lecture, I told you in some communities, a grant of land by a communal head or by family may displace the ownership of corporate ownership of community or family land holding. It's special circumstances. If you buy a land from a family, is it still family land holding? No, it becomes individual. So you have those three methods of land holding under the customary land system.
All right, thank you, sir.
You're welcome. Next. We have the next 5 minutes or 2 minutes to round up the lecture. Any other question? I can see one. Somebody is raising up his hand, but I can't see 1906 something. Hello.
Can you hear me?
I can't hear you. I can't hear you very well.
Right, sir. I have a question, sir. Just I want to clarify something.
Go ahead now.
Sir. All right. So a friend of mine just a land, and it was actually a building, and so when he was about to like proceed with renovating the place, and his plan was to construct a gym. So the building that was currently there, he had to settle.
Before you wait. Before you go further, I don't give legal advice or free legal advice in the class. You restrict your question to the lecture. If you want that one, you come and meet me privately. I don't give legal opinion in the class, please. Any other question?
No problem, sir. No problem, sir. I'll meet you.
You're welcome.
Oh, still landlord. That is new. When?
Well, if you have no questions for me, thank you very much. We meet when again? Is it tomorrow? When is your landlord tomorrow?
Tuesday, sir.
Okay, next week, Tuesday. What time?
Estimate.
What? What time next week? What time is landlord next week?
11 o'clock, sir. It's 11 o'clock next week, Tuesday.
7 o'clock next week, Tuesday, we meet. Thank you
11
very-
o'clock, 11.
11. That's fine. All right. Do have a wonderful weekend. Thank you for having the class. Bye.
Thank you, sir.
You're welcome.
Thank you, sir.
Bye.
Thank you, sir.
Bye.
Good afternoon, everybody. If you could put your name down fast. I have a class now. I'm the host. Thank you very much. I would like to end the meeting. Please put your name
Good
down.
afternoon.
Thank you very much, guys.
He wants to start another class. No.
Please, if you haven't put your name down, please put your name down ASAP. I need to attend another class. Thank you very much, guys. I believe everybody has put their name down. I'll be ending the meeting now. Thank you very much, guys. Have a great one.